Swayam Prabha. Digital India. Educated India.
Let's see a few case laws and how the courts have analyzed. So we'll be seeing the case laws as the judiciary has evolved from time and again. The first case law that we'll be seeing is SP Sampath Kumar versus Union of India, a case that was ordered somewhere around 1986. Now, in this particular case, the court held that it is constitutionally valid for Parliament to create an alternate institution to high courts with jurisdiction over certain matters that are provided that the alternate body also has the same efficacy as that of the high court. So if you need to write an answer that how did the tribunal system actually come into existence, what are the important case laws that are there, it's always better to write the answer with the help of a case law. And if you write the name of the case law and what the court had actually held, it has a larger effect of getting accepted and you getting more marks. Next, in the same case, the Supreme Court held that the appointments should be made by the central government after consultation with the Chief Justice of India or by a high-powered selection committee headed by a CJI or from the current judge from the current High Court. So this is the manner in which the tribunal system was anticipated, was envisioned, and then you have the various acts and the various kinds of tribunals that have come over the period of time. Now, this is one case law that deals with an alternate institution to the already existing and robust judiciary that we have in India. The next case law that we have is L. Chandra Kumar versus Union of India and others, 1997. Now, in this particular case, what happened is a tribunal which the question of law was whether a tribunal can substitute a high court. And it said a tribunal which substitutes a high court as an alternative institution mechanism for judicial review, it is basically for the primary reason to lessen the burden of the high courts, and therefore they must also be accorded with the status of a high court, but yes, they will not have the various other jurisdictions or the other work that a high court generally has. And such tribunals will act as a court of first instance in respect of areas of law for which they have been constituted. Now, for instance, there is a National Green Tribunal. Any environmental civil matter will firstly go before the NGT before the litigants approaching the Supreme Court under Article 32 or 136 or the High Court under Article 226 or 227. And the decision that these tribunals will be giving will be subject to a scrutiny by a high court within whose jurisdiction the tribunal falls. So we cannot say that these tribunals are completely independent. They do have a check and balance within them as well. The high courts are therefore for that matter. Therefore, it is said every court that is there in a particular state will be subordinate to the high court of that particular state. Next, for a tribunal substituting a high court, any weightage in favor of non-judicial members would render the tribunal less effective and potent than the high court. Therefore, the way the non-judicial members are chosen, that needs to be done in a very wise and systematic manner. And of course, people with judicial experience should only be appointed to the tribunals, not with a lot of experience, but yes, people who know how things work in the civil side or on the criminal side. And mostly tribunals generally are for civil matters. You see the Motor Vehicles Act, there is a Motor Vehicles Tribunal as well. There's a Railways Tribunal, as we have seen. Income tax, customs, service matters. So these are the boundaries in which they function. Next, To ensure uniformity in administration, a separate independent mechanism should be set up to manage the appointment and administration of tribunals. And it was in this judgment in the year 1997 this was held. Until such an independent agency is set up, all tribunals will be under the administration of a single nodal ministry, which is or was the Ministry of Law. Then we have recent judgment of 2010, which is R. Gandhi versus Union of India. And in this case, the court held that Parliament may create an alternate mechanism, likewise what was held in Sampath Kumar's case on subject matters in the union list. So this is the difference in the 1986 judgment and the 2010 judgment. It also went ahead and said that there is no need of a technical member if jurisdiction of courts is transferred to the tribunals solely to achieve expeditious disposal of matters. In any bench, technical members must not outnumber judicial members. Now, this is one of the most important proponents that we should keep in mind, that it is an adjudicative body, and an adjudicative body must have more number of judicial members rather than technical members, because having judicial members, they will apply the law that's there, the principles of natural justice will be applied, and eventually justice will be done, may not be done, that's for a different day. Then the third point in this case was only a secretary level officer with specialized knowledge and skills should be appointed as technical members. So you can't just appoint any person. You need to appoint a person of the secretary level, that is a very senior bureaucrat with technical expertise, whether in the consumer arena or the environmental arena or income tax, whatever it may be, they should have the requisite skills along with the experience. The next case, Madras Bar Association versus Union of India and another 2014. In this, it was explicitly stated that the Group A or equivalent rank officers with experience in Indian company law service, that too specifically in the legal branch and the Indian Legal Service Grade 1, they cannot be considered for appointment as judicial members, because such officers do not come from the judiciary. They pass the administrative exams and come, and such officers may be considered for appointment only as technical members. So the difference between a judicial member and a technical member may be a very thin silver lining, but we do need to appreciate the fact that technical members do come from these arenas, and judicial members are people who are lawyers and eventually go on to become judges. Then the administrative support for all these tribunals should come from the Ministry of Law and Justice. You cannot appoint them through regular appointments, but they should be deputed and should come from the ministry. Then, neither the tribunals nor the members must seek or be provided with facilities from the respective parent ministry or concerned department. Now, in the next case, Roger Matthew versus South Indian Bank Limited and others, the judicial functions cannot be performed by technical members. It was clearly and explicitly mentioned that technical members are only for the technical know-how. They should not interfere with the judicial working of the tribunal. Provisions to allow removal of judges by the executive is completely unconstitutional. Otherwise, the executive will have a say on the appointments of judges and technical members in the tribunal, which would again dilute their effectiveness. There will be a uniform age of retirement for all members, as it's there in every other service. Short tenures lead to control of executives over tribunals, causing adverse effects on the independence of judiciary. And lastly, the impact of amalgamation of tribunals should be analyzed with judicial impact assessment. And therefore, there are various tribunals for various kinds of matters and services. So over the years, as we see, the tribunal system has been made a robust functioning system, not only by the legislative or executive work, but also by the judiciary taking proactive steps in ensuring that there is a timely message and a timely judgment, so on and so forth. Then let's come to 2020 when the judgment of the Madras Bar Association versus the Union of India was delivered, wherein it stated that national tribunal commissions should be set up to supervise appointments as well as functioning and administration of tribunals. Members will have a term of 5 years instead of 4 years, and members will be allowed to hold office till they reach the age of 67 instead of 65. Now, one of the reasons this was done, if we can reason it well, it is because you need a proper tenure in office. Like it said, many of the members who come from the judicial or the technical side may be well equipped on the knowledge side, but to get acquainted with the procedure, to get acquainted with the kind of cases that come, you need time. You need like 2 years, 3 years, and by the time you're already skilled and apt with the particular kind of knowledge that you actually need to deliver a particular order, that needs to be secured. Then we have the Madras Bar Association versus the Union of India. Again, a different case with the same name in the year 2021. And in this case, the court struck down provisions to the 4 year tenure and minimum age requirement of 50 years for members. So, as we see from the year 1986 to the year 2021, the judiciary has been proactively instituting various changes time and again to ensure that the tribunal system reaches its apex point, it delivers justice to people and welfare for the people, which is one of the most important things in a tribunal setup and a robust judiciary, along with an executive and a legislature. The judiciary has also taken the steps way beyond just being a mere guardian, but it has also ensured that it gives the tribunals equal teeth, and not only mere teeth but equal teeth that it can bite and be effective in the judgments and order that they eventually deliver. Now, coming to this part of clauses of finality of orders of tribunals. Now, what do we mean by clauses of finality of orders of tribunals? Now, we may so wonder, are these decisions binding? Yes. There is a finality clause that is provided in the statute to declare that a decision by an agency is final, provided that bars an appeal to the court. And there is also the doctrine of res judicata that says a thing or matter, basically a case that has been finally decided on its merits and cannot be litigated again by the same parties before some other court. If your matter has been addressed, it should be addressed by that particular court. While it's pending, you cannot take that and go to any other court and file another case out there, because this would lead into multiplicity of litigation and proceedings. Now, the doctrine of res judicata, as we just saw, is based on the three Latin maxims. First, nemo det lis vaxere pro idem causa, which is no man should be vexed twice for the same cause, because it's not only a waste of judicial time, but it's also a violation of the rights of individuals. Next, interest republicae ut sit finis litium. It is in the interest of the state that there should be an end to litigation, because litigation, if it runs long, does not bring a mere benefit to either parties. There is a loss of the government exchequer, and definitely the person who is bearing the loss is also at loss. And the third, re judicata pro veritate hoc pitur, which means a judicial decision must be accepted as correct. It so happened that if you're not happy, you can definitely appeal to the higher courts, but these are the three Latin maxims on which the wider doctrine of res judicata is actually based. Then we have section 11 of the Civil Procedure Code that prevents multiplicity of proceedings and accords finality to issues. We have bars plea of issue tried in an earlier suit founded on a plaint in which the matter in issue directly and substantially becomes final. Now, all these things, they apply to all judicial proceedings, including that of proceedings that go on a quasi-judicial setup and body as well. Now, in Sulochana Amma versus Narayan Nair, it was held that constructive res judicata, which is another facet of Section 11, sets to not claims raised in a subsequent proceeding where the same ought to have been raised and decided in an earlier proceeding. But are there exceptions to these rules? Yes. In India, if we have a rule, there is an exception also. We have less rules and more number of exceptions. And that's the beauty of the Indian judiciary and the Indian legal system. So, coming to the case of R versus Medical Appeal Tribunal ex parte Gilmore, which is a 1957 case, it was held that an established a supervisory jurisdiction on decision on administrative tribunals. It held that a decision by an administrative tribunal is final when questions of fact are challenged. The decisions of a tribunal, though, can be reviewed on grounds of excess jurisdiction or error on apparent face of record. Now, what is jurisdiction? Now, every court has its own jurisdiction. For example, the Bombay High Court has its own jurisdiction that it will not hear matters from the state of Orissa or from the state of Karnataka. If I am a litigant who is in Orissa and I've faced an issue or in Karnataka, I cannot go ahead and file my case before the Bombay High Court. I need to file it in the state in which I am, in the state in which the cause of action or the problem has actually arisen. Similarly, if there is a tribunal in your state, the action has taken place in your state, the course of action cannot shift, and therefore it is upon the tribunal to see whether they can accept the jurisdiction under which a particular litigant has approached them. Now, in case of mixed questions of law and facts, which are impossible to separate, a decision of a tribunal is final and conclusive. Therefore, in this case, it was laid down that invoking a finality clause does not appeal to a court given there is a miscarriage of justice. Next, in Dhurabai versus State of Madhya Pradesh, in this case, there were certain conditions that were laid down for the jurisdiction of a civil court. First, if the statute provides a finality clause, the civil court's jurisdiction is completely excluded given there is adequate remedy. The only exception to this is non-conformity to fundamental judicial procedure. Next, in this very case, there was a bar on review of adequacies of remedies by statute, relevant but not decisive to sustain jurisdiction of a civil court. Next, in this same case, the challenge to provisions of the particular act as ultra vires cannot be brought before tribunals constituted under the act. In questions of the correctness of assessment, orders of authorities are absolutely final. So if we need to understand this case, it simply is it laid down the conditions for the exclusion of jurisdiction of a civil court, and when it comes down or boils down to correctness of assessment, the orders given by the authorities are deemed to be final. As we saw in Sampath Kumar, the partial exclusion of judicial review is permitted, and a decision of administrative tribunal is immune from judicial review by High Court if the tribunal contains a judicial element that implies that the tribunal contains a judge. Therefore, in India, only a partial immunity to judicial review is permitted. Now, according to Professor Wade, in administrative law, there's the firm's judicial policy against undermining the rule of law to be weakening powers of the court. And as per statutory restrictions on judicial remedies, given the narrowest possible construction, sound policy against uncontrollable power of administrative authorities and tribunals are also important. So if we look in a sense the doctrine of finality of administrative decisions, it needs to be well appreciated that administrative action to be fully completed or to fully complete an administrative action before being subjected to judicial review, administrative proceedings are not hampered. So, For this reasons, generally the administrative action needs to be completely completed before they are subject to judicial review. But are there exceptions? Yes. The first exception to this is when the administrative act is in violation of the Constitution. Now, if the constitution of that particular act says that there should be four members, now if there are three members, there is an exception to this because there was a clear-cut violation of the administrative authority. Second, when the order is not reviewable by any other way and such relief is allowed by law, given the order substantially affects the rights of the aggrieved. And the last, when the order is in excess of jurisdiction. In simple words, a railway tribunal cannot hear a service matter dispute related to a government officer or a government servant from any government department. So it's basically very simple, wherein we need to see that the administrative authority and what is written in law is followed in spirit and also in words, not merely in spirit. Second, the order that is not reviewable by any other way, given the order is being effected to the aggrieved party, this also forms the ground of exception. And last, as we said, the order is in excess of jurisdiction. Next, the doctrine of exhaustion of civil remedies. Now, courts of law shouldn't entertain cases unless available administrative remedies have been resorted to. In simple words, if a case comes before the High Court's primary duty is to look whether all the other administrative remedies were actually carried out or resorted to by the litigant before they approached a particular court. Next, appropriate authorities must be given opportunity to act and correct the errors committed by the administrative forum. If there is an error in the order, the administrative authorities should be given the responsibility and also the chance to correct the same and then bring it forward. Third, enabling statute must provide a procedure for administrative review, a system of administrative appeal and reconsideration. So the judicial action must be complete in all the facets. Are there exceptions to the doctrine of exhaustion? Yes, there are. When there is a violation of the due process, when the issue involved is purely legal, when the administrative action is patently illegal, amounting to a lack or in excess of jurisdiction, when there is an estoppel on the administrative agency concerned. By estoppel, I simply mean that the administrative agency has been told not to act in this particular case, but it still went ahead and participated or took part in this particular case. When there is irreparable injury, when the respondent is a department secretary, you cannot do that because that will amount to a conflict and the principles of natural justice that you cannot be a judge in your own case. When exhaustion of administrative remedies be unreasonable. We need to understand, friends, that administrative remedies orders that come, they need to be very reasonable. When it would amount to a nullification of the claim when the subject matter is a private land, it cannot act. When the rules fail to provide a plain, speedy, and adequate remedy, when the circumstances indicate urgency of judicial intervention, the tribunals must come in and play their role in this. Then, when the involved claim is small, when strong public interest is involved in co-ordinator proceedings, and when the issue is rendered moot or academic. And these are the exceptions to the doctrine of exhaustion of civil remedies. Only under such a process can you exhaust the process of civil remedies and entertain matters as and where it should be. Now, in law, what is one of the most primary importance and of focal importance is that the principles of natural justice must be followed in every order, in every judgment, by every court, by every judicial, non-judicial body, or executive and legislative body as well. The principles of natural justice, especially while adjudicating any case, any matter, must be addressed and they must be redressed as well. And the judgments or orders, they need to be in line with the principles of natural justice. But what are the principles of natural justice? So let's try to understand. As we can see in the picture out there, audi alteram partem, which simply means you need to hear the other side. You cannot deliver a judgment or you cannot give a judgment by just hearing one party to the case. You cannot deliver a judgment by hearing only the litigant. You need to hear both the parties then and there. So, procedural rules that ensure fairness in the process and exercise of governmental power, hearing the other side, fair hearing, and due process. So, audi alteram partem does not only mean that you hear the other side, it also goes to the extent of pointing out the point that you must hear the other side with complete sincerity, with the fairness of judgment, and hearing it by conducting the due process of law. And ingredients of fair hearing are not uniform, they differ from circumstance to circumstances. Now, it may so happen in a case one side may require 50 minutes to present its case, while the party that is defending the case may require only 10 minutes. Now, this is a fair hearing, this is not an unfair hearing. So, therefore, it is said that the ingredients of a fair hearing cannot be uniform, they will differ from circumstance to circumstance. And sometimes the hearing in the form of a full trial is required, and sometimes post decisional hearings are also sufficient. That you make a decision and then you hear the party. In a court of law, this will not happen. In a tribunal system, since we had discussed that it is flexible in nature, it is not bound by the strict procedure of civil and criminal procedure code, they do have the liberty and the leeway to exercise their domain in this particular manner. But are there any essential components to this principle of natural justice? Yes, there are. First, notice. The communication of charges must be made amicably clear to both the parties, and this is a mandatory requirement. An affected person must be given sufficient time to prepare for his case. You cannot just level charges against the other person. You level charges against the other person, and the other person must also have the right to defend himself and the remedy to bring forward his defense in the best possible manner. Now, can the notice be considered inadequate? Yes. The notice that is served upon the other side can be considered as inadequate if the notice contains unsubstantiated particulars not specific as to the consequences. Now, if there is a service matter and a person has been dislodged from service, the notice must state as to under what circumstances and what were the reasons under which law a particular person has been dislodged or dismissed from his service. Now, more than one grounds and consequences which is not identified should not be mentioned. You need to mention grounds and consequences that is identifiable to the act that has taken place. And notice may be dispensed with where the person avoids notice. So in this case of Punjab National Bank versus All India Bank Employees Federation, it's a 1971 case from the Supreme Court of India. In this case, the penalty was imposed upon the respondent, not specified in the notice. Because the notice contained details of the charges imposed, the penalty held was invalid. Therefore, in this case, it was held that a notice should be clear and unambiguous or cannot be considered reasonable and proper. And this was held in the Keshav Mills Company Limited versus the Union of India. So, in essence, please note that whenever a notice is being served, the name of the party to whom it's being served, the address where it is being served, most important, the charges that are imposed, all of these things must be very clearly and amicably put forward to the person receiving the notice. Next, hearing. Now, hearing may be oral or written depending on the complexity of the case and the level of the case in which it is. Now, in case involving complex questions of fact, oral hearing becomes really necessary. You cannot finish off this matter just by a written hearing. You need to have an oral hearing in this matter. For example, in tax matters or matters of deportation, customs, service matters, you need to have an oral hearing which is subsequently precluded by written submissions as well. And next, no evidence should be collected in the absence of the opposite party. And this was held in Stafford versus Minister of Health, that when the other party is not there, you should not collect evidence in their absence. Now, opposite party's presence is required while furnishing information regarding previous convictions which the court might rely upon. Please note. Now, in Hiranath Mishra versus Principal Rajendra Medical College, it was held that disclosure of material may be summary or the copy of the materials relied upon. Now, in cases relating to disciplinary action against civil servants, copy of material must be supplied. The documents do act as one of the most important kind of evidences to reach the conclusion of the case in the best possible manner. Right to cross examination, yes, it is absolutely there, available if oral evidence has been taken. Then you do have the right to question the other party through a lawyer or as the case may be. Further, applicable to labor cases, disciplinary cases of civil servants, employees of statutory corporations, taxes, etc. Because if a person has been dismissed, you will be calling the departmental head, you will ask him why the person was dismissed, then you will have the chance of cross examination. Therefore, right to cross examination also forms a very important element under the head of all the alterum partem. Next. In this 1972 case of Carnarvon and Company versus Collector of Customs, a person who gave relevant information regarding the case was not cross examined, and it was held that an informant who is giving relevant information or even mere information needs to be cross examined in presence of the appellant on statements made to the customs authority. In a sense, if the cross examination is going on, it must be held in the presence of the other side as well. So, a right to legal representation also forms an important part of audio alterum partem, which is a right to request for a right to counsel. That is, if a person is arrested, he has a right, or if a person has been charged or framed, he has a right to appoint a lawyer, because not everyone will be well equipped with the various kinds of law under which a person is charged. So, in one of the cases in J.J. Modi versus State of Bombay, the appellant denied right to legal representation, and it was held if assistance of a lawyer is part of a reasonable opportunity of showing cause, denial is a violation of Article 3112, and the principles of natural justice are being completely violated. Are there exceptions to this? Yes, there are exceptions. There is a statutory exclusion, there is a legislative function, authoritative nature of the administrative order, impracticability, and interdisciplinary action. Under these four circumstances, only audio alterum partem may be excused. Next, the next principle of the principles of natural justice. Nemo ded esse judex in propria causa. What does it mean? As we can see in the picture, justice, everyone his due right, reality, fair representation, impartiality, claim. It simply means no man shall be a judge in his own cause. If it's a service matter, the head of the department has been dismissed, he cannot be a judge or he cannot be a part of the panel that is actually deciding this particular case. And this is the second principle of natural justice. Prince and next, essential safeguard to uphold the principles of justice and fairness in any judicial or administrative process. Therefore, it is very important to hold the principles of justice in fairness in judicial or administrative process. It's based on other legal principles such as justice must not only be done, but manifestly and undoubtedly be seen to be done. What it simply means is justice needs to be done in the best possible manner, and it should not seem that justice is being done in an unfair manner where one person is being biased towards the other. Well, that brings me to the word bias. The operative prejudice, conscious or unconsciousness, resulting in preconceived opinion or predisposition regarding a person or issue plays a significant role. And the objective is to ensure a, the public that there is impartiality of the administrative adjudicatory process, and decision as a result of bias is a nullity, and the trial of a quorum is non judice and therefore not before a judge. Now, this is also known as the rule against bias, and there should be absence of consciousness or unconsciousness prejudice to either of the parties to a case. And what are the types of bias? Now, let us see what are the kinds of biases that we have seen. Now that we have seen one part of the principles of natural justice, we are seeing the second part of the principles of natural justice, that is, no man shall be a judge in his own cause. The pecuniary bias is referring to the monetary interest that a judge may have in a case. The rule is that the least pecuniary interest in the subject matter of the litigation will disqualify a person from acting as a judge. Now, a very old case, in the Bonham case, what happened is Dr. Boham was fined by a college of physicians for practicing in London without license of the college. The relevant statute provided for equal distribution of fines between the college and the king. The claim disallowed for college's financial interest in its own judgment and became a judge in its own cause, and therefore it could not take money for the practicing license that was not there. So therefore it is very important to understand that the claim was disallowed and the financial interest was not seen. So the college, since it was a part of the entire procedure, it became a judge in its own cause. Then we have the case of J. Mohapatra versus and Company versus State of Orissa. In this case, decisions of textbook selection committee invalidated. Members of the committee were authors of the books. Withdrawing members who authored books from committee insufficient while their books are considered for circulation among students. Now, this is with regards to a pecuniary bias. Let's see the second kind of bias that is there, that refers to a situation which is where the judge is a friend, relative, business associate of a party to a case. Reasonable evidence of bias necessary to challenge a decision. For example, my son is involved in a case and the matter has been listed before my court. This is a personal bias because my son is there. I will definitely have some bias towards him. I may not be able to render justice to its complete and fullest essence. And therefore, it is said that a reasonable evidence of bias necessary to challenge a decision is there. So there are two tests in this regard: reasonable suspicion of bias that looks mainly to outward appearance, and second, a reasonable likelihood of bias that focuses on the court's own evaluation of possibilities. In A.K. Kripnaik versus Union of India, the regulating dealing with preparation of list of suitable candidates for the post of ex-official chairman of the selection board was challenged. Now, the selection committee's decisions were violative of the principles of natural justice. Why? Because the mere presence of the candidate in the selection board would definitely influence decisions of other members of the board as well. That can lead to a bias. So the principles of natural justice are applied to judicial, administrative, and executive decisions as well. Then there is the third part of bias. We have seen a pecuniary bias, a personal bias, and an official bias. Official bias arises when the judge has an interest in the subject matter of the case. For instance, there is a land dealing that is there, and in a particular land, an illegal construction has come up. That time it may not be legal. Today, by some means, it is illegal. I have purchased a flat in that particular construction. So, this is something where I have an interest in the subject matter of the case. So, there is a matter bias that is related here. And this can be alleged in cases where there is total non application of the mind or acting on the advice of a superior. Now, if a judge is acting on the aid and advice of some senior member, it is also known as an official bias. In the next case, Gulabuli Nageshwar Rao versus APSRTC, the Supreme Court quashed the decision of the Andhra Pradesh government to nationalize road transport. Now, they invalidated as the secretary of the Andhra Pradesh State Regional Transport Corporation conducted the hearing and he had an interest in the subject matter. Next, the next kind of bias is a preconceived notion bias, wherein a decision maker already has an opinion or idea of a case before it is heard, because that will generally lead to the general human tendency of me having a bias towards that. Next, bias on account of obstinacy, a situation where a decision maker shows unreasonable persistence in upholding their own decision. Now, there are valid reasons to reconsider the decision because the violation can be done indirectly, though not directly. Seeing this case of 2009 of A.U. Qureshi versus High Court of Gujarat, the judicial officer dismissed from service after being found guilty in a disciplinary inquiry. So the appellant was previously acquitted as an accused under the Gambling Act and returned the seized money. So the complaint filed against the appellant, leading to a disciplinary inquiry. Now the High Court recommended the appellant's dismissal based on the suggestion of the disciplinary committee. Out here, when the matter went to the Supreme Court held that it is completely improper for the disciplinary committee to judge challenge against the same dismissal order while it acted as a pure judicial authority in its capacity. Next, reasoned decisions. So, this is the third pillar that we have in the principles of natural justice, which is the principle of reasoned decision. As I have been stating, friends, every decision must have a reasoning to it, whether it be an order, whether it be a judicial reason or a note, it must have a reasoned background to it. So evolved recently, not recently, quite long years back, but in judicial parlance, we say that things have evolved recently if something had evolved in the year 2010. So this is recognized in India and USA is yet to recognize by English law. That's for a different matter, for a different day. Now, decisions of administrative authorities must disclose reasons. Why? Because we're reviewing authorities to examine whether they are taken on the basis of relevant consideration or suffer from factual or legal infirmities. Now, speaking order coined by Lord Chancellor Earl Cairns, essential for judicial review. Now, so what are the characteristics of reasoned decisions? First, it should contain adequate reasons in support of the decisions. No particular form of recording is required. And third, applicable to public and private laws. So the reason must be or must have an element of adequate reasons to conclude or come at a finality of a decision. It And the introduction of fairness in administrative power helps minimizing arbitrariness and maintain right to reason. A record of reasons operate as a deterrent against similar cases because you can't just deliver a judgment and later be like, we do not have an idea of this particular judgment. Therefore, every judgment and order must have a reasoned line of reasoning that concludes to a particular reasoning. Next, doctrine of justiciability. Recorded reasons are subject to judicial scrutiny, and therefore it's said that it is very important to record reasons because important safeguard against arbitrary exercise of power by adjudicating authority. You never know if there is an order that was completely given in an arbitrary manner. You can only realize that when you have the reasons and then you read the order and then it makes sense. So if reasons found are unclear or not in support of conclusion, decision may be set aside. So the exceptions to reasoned decisions are externment orders and decisions by way of court-martial proceedings where these do not come into the picture. Now, in a 1978 case, that is Sunil Batra versus Delhi administration, now this examined Section 56 of the Prisoners Act 1894. Now, this observed implied duty of the jail superintendent to give reasons for putting jail fetters on a prisoner. Otherwise, this act will be considered invalid as per Article 21 of the Constitution. So it doesn't only extend to the judicial activities by tribunals and courts, but it also extends to the executive who is carrying out this duty on a day in and day out basis. They also need to observe these things. They also need to observe their reasonings and their reasons as to why they are putting a particular person or fetters on a prisoner. So you see, every order or everything that is done in a government institution needs to be backed by reason and by order. Now, coming towards the exceptions to principles of natural justice. As we can see in the picture, Patna High Court quashes order and notice for violating principles of natural justice. Well, as we know that justice is blind, there is a ribbon on the eye of the lady who is holding the scales and the sword. Justice sees, cannot see, but can hear. So what are the exceptions to the principles of natural justice? Now, in case where there is an emergency and there requires a prompt preventive or remedial action that needs to be taken. Now, there is a flood or a natural calamity that has taken place, and a person who is actually there as the departmental head is not working, is not functioning properly. There is a humane hue and cry. In such a kind of emergency, there can be a preventive or remedial action wherein you may not require to give a reasoned order to dismiss that particular person because that is the need of the time in case of an emergency. Next, in case of confidentiality. Now, there are many matters that are very confidential for various kind of reasons. It may be for the protection of a person's life. It may also extend to the aspect of national security. So cases concerning security of the state and public tranquility, or to maintain the higher order, or to maintain the societal degree of calmness and consciousness and composedness, it may be required. Third, in case of purely administrative matters where cases of academic adjudication is involved. Fourth, based on impracticability. Administrative impracticability justifies the violation. Fifth, cases of interim preventive action, where an order is preventive but not final in nature. Because friends, please understand, When a case is ongoing, there are many orders that a court passes. Now, these orders can be for various things: for a party to appear on a particular day and date, for a party to bring before it a particular document, for a party to produce a particular kind of evidence. So, all these cases where there is an order, but that order may not be final in nature, is an exception to the principle. Cases of legislative action. Rules plenary subordinate lay down a policy without reference to an individual. Next, if no right has been infringed, where there has no wrong that has taken place, of course, there will be an exception.